Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
They got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
This is the next search on February 28, 2020, 7:44 p.m. How does the FBI find people? People be spelled E-O-O-P-L-E. Did the defendant find out how the FBI finds people in this case? Or she found out? What more do you need to see?
All right. Oh, whoa. You can't see me, can you? Whoa. What happened there? We went black. Weird. We're in the dark here. Okay, we'll try to reboot a camera and see if that helps. But hello, good morning. Don't mind me. I was just dusting my office. Okay, we're good to go now. That being said, camera 4 is a no-go. It's gone. This is camera 4. This is the whole setup. Let's see. Let's do some diagnostic work here. Okay, it's turned on. Looks like it's working. Plug it in. Well, now we get this, which is a small version. Not exactly what we need.
This is not Burger King. People do not get to have it their way. The zombie apocalypse may be upon us.
We'll try again. We'll just keep trying, Turned off and on again, off and on again. You know whose help we could really use about right now? Angela, we could use your help. You were first in chat.
If they didn't, I would lose my mind.
I would lose my mind.
I saw a chicken fight.
Scratch all that. Oh, that was terrible. I apologize.
When are we going to break for lunch, Judge?
GoPro is broken, apparently. Not a sponsor, by the way. Okay, so plug it in. Wait for the beep. Ready?
Have them send someone with more experience.
There's no beep. Oh, there's the beep. Okay. Turned on. Features activated. HDMI.
I was kicked back, taking it easy.
Time's good. There we go. Now we plug it in. Yeah, it's not working. I don't know what I did.
Subject matter jurisdiction.
Because I didn't do anything differently today with this camera than I normally do. But let's continue as if we had a second camera. Let's see, Megan Easton. Good morning.
May be upon us.
Congratulations, Megan. Thank you thank you, Megan, for giving out one membership the first thing this morning. Breezy also gave out a membership. DSN gifted a membership, and Frosty Jen upgraded the membership to jury, which
Nell and Murdoch stole it.
For those of you who are just sitting on the front row, you may have noticed the bench is a little firm. Jury has padded seats. I'm just saying. So thank you very much, Frosty Jen. Hope you enjoy that. Angela, by the way, congratulations. You were not first in chat. You were second, but the internet winner re-gifted it to you And so now you are, it's as if you were first in chat. And unfortunately, the rules of the internet, the way things work, it cannot be re-gifted again. So even if today's really a bad day for you to own the internet, hey, look at this. You fixed it already, Angela. Thank you. Thank you. You fixed everything. Look, it's working. Computers, buttons. Yeah, now I'm just having fun. Okay. Thank you, Angela. As your first job, you fixed the internet. Appreciate it. Now we can do this. Welcome to the Court of Public Opinion. I'm the Recovery Addict. Thank you very much for joining us this morning. It feels like a Monday, the way things have started. But it's not. It's not.
If they didn't, I would lose my mind.
Guess what today is?
It's hump day.
Hump day! Welcome to Wednesday. We made it all the way halfway to the end of the weekend. End of the week. Halfway to the weekend. I'll try that again. We made it halfway to the weekend. Oh. Ooh, that was a rough one. I'm sure it was like a 6 out of 10 for my son, but we made it to Wednesday. Happy Wednesday today. That was a bad day to do some reading on, but we are going to do some reading today because we have a new hot, spicy document that dropped. Before we do that, though, we have to sing. We have to sing because people have to be celebrated. Celebrations must ensue. Specifically for Tower Hill Girl, Jessica, Rita, and Jenna, all celebrating their special day with us today. Let me just, clear out my throat there. That was a little rough. All right, so we are going to sing. By we, I mean all of us are going to sing together. Tower Hill Girl, Jessica, Rita, and Jenna, please warm up with me if you would. La 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 la. Beautiful. Excellent, excellent. Okay, places, everybody. Shoulders back, deep breath. Project your voice to the back of the room. Blend your voice with those of your neighbors as we sing to these wonderful people who have had birthdays or happy birthdays today. Here we go. Happy birthday to you. Happy birthday to you. Happy birthday to Tower Hill Girl, Jessica, Rita, and Jenna. Happy birthday to you. Tower Hill Girl, Jessica, Rita, and Jenna, happy birthday. I realize there are a million places you could be, a million people you could be with, but you've chosen to be here with us. The privilege and pleasure is all ours. Thank you very much. Hopefully, you have a little pleasure being here as well. Hopefully we don't make it miserable for you. Help yourself to free stacks of pancakes at whatever establishment will honor the time-bound tradition of serving free pancakes to people who have birthdays. I would suggest IHOP or Denny's, as long as they're still both in business. Congratulations. We will fade the music out, but the party doesn't stop. You get to celebrate all weekend long, and that's, you can say that I told you it was okay. I told them it was okay. Happy birthday. Thank you very much. Welcome all, one and all. It's good to have you here at the, let's see. You mean we can't look at the back of your head today? No. This is my male pattern baldness check is what I do. I'm like, it's looking a little thin. I'm seeing some daylight back there. So that'll just keep me humble is what it does. All right, let's see. Melanie Schuler. I can't say U and Y together, right? Schuler. Melanie, welcome to 7 months. I cannot say your name for the life of me. I don't know. I wasn't taught how to say those letters together when I was a kid. It confuses my brain and my mouth. Sue, welcome to the gallery. Brand new member. Welcome, Sue. I guess we should have probably warned you before you became a member, but you can't leave. Sorry, it's one of the rules, so sorry. Sandy Beach, I'm almost orange. Thank you, Recovery Addict, and everyone. I said 14, but 11 months. You are almost orange. You just about hit the year mark. Very, very soon that's going to happen. Look who's here, Cachette. This is starting to get embarrassing, Scott. I need to count backwards. Also, that hump day call was one for the books. It was pretty good. It was all right. I'd put it up there in one of my better performances. So I'm counting 17 months, by the way, Cachette. Congratulations. AZDCS Oversight gifted a membership this morning. Thank you, AZDCS, for your generosity. Morgan Westfall, member for 1 month. Good morning. Hope you're having a wonderful day. Morgan, happy. Guess what, Morgan? Today, or recently, you just got a new colored courthouse. Did you notice that? Up by your name, that little thing? I'm putting it right there so you can see it a little better. Yeah, it's brand new. Over time, as you have a membership on the channel, that courthouse is going to change colors, and yours has already changed to blue. Congratulations on that. Thank you very much for your support. Snakes Will Hiss gifted a membership this morning. Good morning to you. Erica W, member for 7 months, says, so happy to be here with all you wonderful people. Peeps, thanks for the great place to be, RA and the mods. Thank you for mentioning the mods. They do amazing work. OJ Sean White, OG. I'm not sure where I got the J from, Sean. 9 months. Thank you for everything you do. OG, thank you. Thank you very much. Thank you for everything you do as well. Thanks. It wouldn't be the same without you, Sean. So thank you. Coordinator Kitsune. Coordinator Kitsune. Is that better? I'm not sure if the E is supposed to be pronounced or not. It says, woohoo, almost yellow. You're 5 months already. Next month it will be yellow for sure.
Have them send someone with more experience.
Lady Draconis says, what a month to be following cases. Happy to be here with you all. Lady Draconis, thank you very much. It was great having you on the panel the other day. That was wonderful. And love all the great stuff you do here, as well as the great work you do for Rob over on the Law and Lumber channel, which all of you should be subscribed to as well. Congratulations, Lady Draconis, on 9 months. I think, did I miss anybody? Let's see. We had Frosty Jen, Melanie Schuler. Was that close? I just said it quick and mumbled it. Maybe that helped. We've got Sandy Beach, Cachette. I think I got everybody there. We're all caught up on that end. Let me check the chat before we go. I'm going to start by reading a document today, because we knew that, Alec Baldwin's trial ended with a big explosion, volcanic explosion. Schuler is pronounced like greeners. Certiorari, yeah, I can't say that one either. Certiorari. That close? This is why I can't be a lawyer. It's a couple of the key words I just can't get right. But I figure if the judge calls it voir dire or voir dire, or they mix it up, I can at least mispronounce a few things. It's Skylar. Okay. Oh, man. Skylar. How do you get Skylar out of that? Yeah, shit. New member who dis. Christy, we might do the witchcraft trial. If we do, we're going to do a late pickup. Here's why. I've got a meeting at a venue midday today, and I don't know how long it's going to take. So we're gonna do a little court hopping. We've got a big document that's really spicy, honestly. A big document that dropped last night in the Hannah Gutierrez case. I mean, she's already serving time, but I guess the case is still there. And as we expected this because of the big blow up that happened with Baldwin. So we're going to go through that this morning as well. Snakes Will Hiss. Your reading partner is in the chat. Welsh Lady reads. I'm not set up to take any guests, unfortunately, for reading. I'm gonna have to do this one on my own. I forgot to do this through StreamYard. So I'm daring. Okay, Angela. I actually, when I saw the internet was gifted to you, Angela, I thought, I'm going to try this. I'm going to try to say your last name. I chickened out. But now you've double dog dared me, and so now I have to do this. So I got Angela, right? Djordjevic. Was that close? Djordjevic? I think I nailed it first try. I'm just saying. Let's see. It's my husband's last name. It's his fault, says Melanie. Melanie, you might have to call in and just give me a pronunciation guide. Or mail it in, write it in crayon so I can understand. Karina, oh my goodness. I can't read that one. Let's see. Okay, the last C is pronounced C, not as a K. They make the same sound, don't they? How does... Are you pulling my leg? C and K make the same sound, don't they? I swear I learned this in elementary school. All right, we'll get past the. I will get demonetized by trying to pronounce names. I probably will. All right, let's move on to what we came here for. I'm excited to get this. Try my name. Keisha Pickerel. How did I do, Keisha? Nailed it. I think that was an easy one. C can make a sound. Georgiavis. Man, maybe it's a ch. Okay, we'll work on my pronunciation. Oh, Keisha. Nope, sorry. I tried to change it. I call you Katia, which is probably wrong. Katia Pickerel. Okay, I'm just digging a hole and getting deeper and deeper. So what we're going to do is we're going to jump right now to our document, which is this spicy document from Attorney Bowles. You remember him? It was Hannah Gutierrez. There's a quick lawsuit, right? If I mix those names up. Yes.
Shame on you, sir.
Shame on me for doing that. Hannah Gutierrez's lawyer. It's okay. We're not all blessed with names like Scott. I think my parents, when I was born, they're like, yeah, he's going to struggle. Let's give him an easy one. Here's an easy one. Knight 01007. Is that a zip code?
There's a lawsuit.
Yeah. Yes, this one is expedited. Expedited means fast, right? That's how I order all my shipments from Amazon. No, just kidding. Prime comes fast enough for me. But we are now going to transition from failure of pronunciation to more failure of pronunciation as we start this. This is the state of New Mexico versus Haag Gutierrez-Reed, titled Haag Gutierrez-Reed's expedited motion for new trial or for dismissal for discovery violations under the court's inherent power. Now, I think this title could have been longer, and you'll see why when we get to the end. But so they're asking for either a new trial or for dismissal, and this gets juicy. Oh man, this gets good. Let me make sure you guys can see everything that I can see. Looks good. All right. Defendant Haag Gutierrez-Reed, by and through her counsel of record, Jason Bowles and Monica L. Barraris, there's another name, respectfully moves this court for new trial or for dismissal for severe and ongoing discovery violations by the state. This motion is made pursuant to Rule 5-614 of the Rules of Criminal Procedure, Case Law, and the Court's Inherent Powers. 1. Baldwin's trial exposes extreme misconduct. Special Prosecutor Morrissey lies to this court under oath. I mean, he goes off. He fires the big gun first. That's what he did here. In the hearing on July 12th, 2024, in Mr. Baldwin's case, Miss Morrissey took the stand, calling herself as a witness, and lied to this court several times. Corporal Hancock testified that Miss Morrissey was in on the decision to file the Teskey rounds in a separate file. On direct examination, however, Miss Morrissey stated she never knew it would have a separate file number. Miss Morrissey alleged in response to cross-examination that Erlinda Johnson had resigned that day because Miss Johnson didn't want a public hearing on the Brady violations. This was false. In a media interview the same day, Miss Johnson explained that she resigned because of her ethical duties as a prosecutor and that she had argued that the case should be dismissed by the state because of the late disclosure and that she was overruled, obviously, by Miss Morrissey. See Baldwin prosecutor on resigning. Erlinda Johnson interview with Chris Como, available on X. Miss Morrissey instead decided to plow ahead in her continued win-at-all-costs attitude in the Rust cases. Second, Miss Morrissey represented in response to questioning that she has asked her prior paralegal to resign. That was actually untrue. The paralegal decided to tender his resignation unilaterally after sending several emails to the DA's office about his working conditions and the conduct of Miss Morrissey that led to his unilateral decision to resign. The paralegal emailed this undersigned counsel and executed an affidavit. So he's like, the guy talked to me, and I've got a signed statement from him as well. Third, Morrissey represented that undersigned counsel did not want the Teskey rounds and believed they inculpated Miss Gutierrez-Reed. That is an absolute falsehood. Some background is necessary on this point. The state had been aware and had access to Teskey for years. Seth Kenney called Teskey during November 1, 2021 interview with then Detective Alexandria Hancock, after which Teskey sent a picture of a sampling of ammunition, and the sampling had bronze primers and didn't match the live ones on the set, which had nickel primers. There was no further follow-up by the state, even though the undersigned counsel texted Detective Hancock, asking her to contact Teskey. Detective Hancock also misrepresented at the hearing, saying she called Teskey multiple times with no response. Hancock in text messages told undersigned counsel she had already talked with Teskey. Yes, I've been present for most of the phone calls and have spoken to him. And also saying, I'm aware, I've seen them, and spoke to Troy. Hancock never tried to contact him, despite her testimony to this court. Then, in a November 2nd, 2023 pretrial interview of Teskey, the rounds were again discussed, this time with Special Prosecutor Morrissey. During the interview, Morrissey specifically asked if Teskey would give her the ammunition from the batch that Reed and Kenney had taken to the 1883 set. Teskey agreed he would preserve it and provide it, and Morrissey indicated he should, and that she would work with law enforcement to collect it. Thereafter, Teskey was afraid to do anything with the rounds except preserve them for law enforcement, which he did. Morrissey never followed up. The undersigned sent an email to Morrissey on January 8th, 2024, asking if the state was going to retrieve the rounds and test them. Exhibit F. Counsel stated in the email that testing was important to compare the powder of the Teskey rounds to the powder in the live rounds found on the Rust set. This had to be done by the FBI through the state, as the FBI had done the original testing and analyzed the powder. Undersigned counsel had repeatedly told the state that it needed to test the Teskey rounds and make this comparison. That same day, however, for the first time since November 2nd, Ms. Morrissey emailed back that she did not plan to retrieve or test them because she found them visually dissimilar, and not relevant. Astoundingly, Ms. Morrissey told this court in the July 12th, 2024 hearing that she had never seen these rounds until July 12th during the evidentiary hearing. It was clear in that hearing that 3 of the rounds were visually like the Rust set rounds, which contradicted Ms. Morrissey's statements in her January 8th email to undersigned, and Ms. Morrissey's in the court statements from July 11th that the rounds were not visually similar. See also Erlinda Johnson interview, Supra, noting that the 3 of the Teskey rounds were visually like the Rust set rounds, and indicating that this had potential exculpatory value of the theory of sabotage. Further misconduct by the state unearthed in the hearing was that CST Popple had been directed to place the Teskey rounds in a separate case file with a separate number, not Rust, and create a report that was also filed in that separate case file so that it would not be disclosed to the defense. Corporal Hancock testified that Ms. Morrissey was present for the meeting and decision to place the rounds in a separate case file. In other words, Special Prosecutor Morrissey was in on the decision to hide the rounds and report on them in another file. Moreover, CST Popple and Morrissey misled this jury in testimony on July 11th, 2024, indicating that the Teskey rounds were visually dissimilar to the Rust set rounds and therefore immaterial. That was proven false a day later when this court opened the box and inspected the Teskey rounds. That was epic, watching the judge do that. Let's see. Far from the distancing from the Teskey rounds, defense counsel recognized their potential exculpatory value and had the state tested them. However, by the time Ms. Morrissey indicated that she did not plan to retrieve them on January 8th, it was too late to utilize these rounds and impossible without the FBI comparison on the powders. This court had also made clear in one of the motion hearings around that time that there would be no continuance of the Friday, February 28th trial date for Ms. Morrissey. Regardless, without the state testing the rounds, the counsel for the defense was unable to utilize the powder comparison. Teskey then turned the rounds over to the sheriff's office on March 6, 2024, and the defense hoped that the sheriff's office would finally test and analyze those rounds, while Ms. Gutierrez-Reed pursued her appeal. Instead, the state placed them in a separate case file and attempted to hide them. Erlinda Johnson recognized the import of the rounds, as she stated in her interview, as soon as she saw the 3 silver primer Starline brass rounds on July 12th, when the court took the rounds out of the evidence box. Ms. Johnson indicated that it had made the theory of sabotage a possible defense theory and defense assertions that Ms. Gutierrez-Reed was a wonderful armorer. This goes to the foreseeability element for Miss Gutierrez-Reed as well, and could have been more exculpatory in Miss Gutierrez-Reed's case. The import is that Miss Morrissey and CSC Popple made misrepresentations to the court and jury regarding the Teskey rounds and the circumstances surrounding their late disclosure. These misrepresentations highlight the continued discovery abuses and fraud perpetrated and attempted to be perpetrated on counsel for the defense of this court by the state. Counsel for Ms. Gutierrez-Reed knew that Teskey had some rounds from the same batch and is not making that failure of disclosure the sole basis for this motion, except to the extent that they show ongoing misconduct of the state and failures found by the court. Although counsel for Ms. Gutierrez-Reed was also never provided with a copy of the police report or lapel video concerning those collected rounds. These additional acts by the special prosecutor should inform, however, the egregious Brady violation regarding the Haag report and the Giglio, I think I said that right. I have to be careful there. Violation regarding the Seth Kenney interview that was disclosed only after trial. The court stated on July 12th that the integrity of the judicial system demanded that the court dismiss Mr. Baldwin's case with prejudice. How could it be any different with Ms. Gutierrez-Reed's case with this proven litany of serious discovery abuses? The intentional withholding of crucial evidence, Brady and Giglio, by the state has compromised the integrity of the entire judicial process. Justice demands that Hannah Gutierrez-Reed's conviction be overturned immediately, ensuring that the legal system does not perpetrate this core affront to our system that has been watched all over the world. Introduction and factual background. At a stunning evidentiary hearing on Friday, July 12, 2024, in Mr. Baldwin's trial, this court found that the state had committed an egregious discovery violation by suppressing material Brady evidence regarding the ammunition rounds that Troy Teskey turned into the Santa Fe County Sheriff's Office on March 6, 2024. This court entered the extreme remedy of dismissal with prejudice in Mr. Baldwin's case, finding 1, that the special prosecutor and sheriff's office suppressed evidence of the rounds that Mr. Teskey turned in. 2, the evidence was favorable to Mr. Baldwin as impeachment evidence and potentially exculpatory. 3, the evidence was material in that the late disclosure impacted the fundamental fairness of the proceedings. 4, the state's conduct was highly culpable in failing to provide this discovery and unilaterally withholding a report on the Teskey rounds. 5, the state's willfulness was so close to bad faith as to show signs of scorching. This was highly prejudicial to Mr. Baldwin and his preparation for trial. 7, the sanction of dismissal was the only appropriate remedy for the egregious conduct. 8, despite the state's repeated disclosures to defense and the court that they had complied with all their discovery obligations, they withheld critical evidence. And 9, dismissal with prejudice was necessary to preserve the integrity of the judicial system. See YouTube. See moment judge throws case out against Alec Baldwin. I love how he cites. Just search this on YouTube. There's no link. Just search this on YouTube and call it good. I think that's actually a long crime video. This is, of course, the same special prosecutor and same sheriff's office that handled the Gutierrez-Reed case. In the same way as Mr. Baldwin's case, the state represented to counsel and to this court that it had complied with its obligations under Rule 5-501. Please see State Certificate of Compliance filed February 12, 2024. Yet, after the trial concluded, the state continued its pattern of discovery misconduct, disclosing a completely new interview of Seth Kenney and a third expert report of state's expert Lucien Haag. Please see Exhibit A to Hannah Gutierrez-Reed's motion for immediate release for detention under Rule 5-402, filed on June 27, 2024. On April 8, 2024, a full month after Gutierrez-Reed's trial had ended, Ms. Morrissey called counsel for Ms. Gutierrez-Reed and disclosed an entirely new Seth Kenney interview and statement that contained numerous points that could have been used in Kenney's cross-examination. Also, the state withheld bombshell exculpatory evidence that it had a constitutional obligation to disclose, and that would have resulted in a fundamentally different trial and likely a different outcome. As the court is aware from ongoing proceedings in Ms. Gutierrez-Reed's and Mr. Baldwin's case, despite having in its possession a report from its own experts stating the firearm used on the set of Rust contained unexplained tool marks on critical surfaces of the trigger and sear, which, 1, likely were not the result of the damage incurred during the FBI's impact testing, and 2, do not appear to be the original manufacturing marks or use and abuse tool marks on their irregular or their irregular orientation. The state buried this information and never disclosed it to Ms. Gutierrez-Reed. But not only that, the state then called the expert at trial and sat idly by as he perjured himself during cross-examination. In doing so, the state suppressed exculpatory material in violation of the U.S. and New Mexico constitutions, suppressed a testifying witness's written statements in violation of Rule 5-501A5, and committed additional violations of the U.S. and New Mexico constitutions during trial. This conduct is beneath what the court should expect from a duly appointed officer of the state tasked with doing justice. These late disclosures, occurring after trial had concluded, violate Rule 5-501H. There is a reasonable probability that the outcome of the trial may have been different had the state complied with its obligations. Aaron Olivia, welcome to the gallery. Love the Yellow Courthouse. Thank you very much. I appreciate your support. The suppressed Seth Kenney interview. Now let's go into that, shall we? In the Seth Kenney recorded interview, conducted well prior to the trial of Ms. Gutierrez-Reed, there's no date contained in the interview, but it occurred before her trial, Mr. Kenney makes the following material statements that counsel for Ms. Gutierrez-Reed would have used in cross-examination. This is what Seth said. 1. There is a standard that the prop master, Sarah Zachary, is the boss, and if something goes missing or stolen, she must report it. She is managing things which allow the armorer to focus on guns, and Sarah is everything else. 2. Hannah grew up on the set of movies and has a lot of immersion in set industry. She has more experience with Westerns than Seth did up until 1883. Down here. Apparently, they need the car keys to drive away, so we'll see you. Love you. 3, says prop masters who handle guns won't call out armorer to test bullets. 4, mentions that sheriffs confused replica gun with a real gun. 5, Sarah told him that Hannah was doing great with the guns and the director was happy. 6, Seth heard nothing but good things about Hannah's skills, all the stuff that came out about safety he hadn't heard. He felt like people were piling on after the fact. 7, he mentions that the anonymous hotline, and if there was something going on, why nobody called the hotline. 8, Alex Hancock has been cool, but I busted her chops on the search warrant. 9, says he got 325 rounds from Thel Reed. 10, says sabotage could be anyone on the set. 11 says it's a boys' club. Alec Baldwin trusts AD because he's a man. And if she got pushed around, if she said she got pushed around, no one would disagree. She's got the experience. If she ever came up with that kind of defense, then I think we'd finally, you're going to be real about this thing. Yeah, that was a direct quote. 12, if the camera crew didn't feel safe, well, then call the hotline. 13, it's kind of suspicious to me. If they got their hotels, would they have said they didn't feel safe? Yeah, that's talking about the camera crew and why they quit. They didn't get hotels where they wanted them. 14, he talks about Sarah's accidental discharge. Sarah was super responsible and apologized to everyone. Hannah was trying to punch down on Sarah for accidental discharge. Accidental discharges happen. Mentions Tim McGraw, Daniel Craig, and Denzel having them. He told Hannah to let it go about Sarah's accidental discharge. 15, as to Hannah, says AD and Baldwin, how are you not making sure a 24-year-old armorer has every ounce of support? 16 says she's got the experience and history. She had more set time on Westerns than I did before 1883. Sarah was collateral damage. He told her he would find her an adult armorer. Hannah came out strong. She was pushed around by Baldwin and AD. Prop department needs every ounce of support. He says sabotage is... Wait. I have to... Is bull... There it is. Several of these statements are new and different and would have been critical to cross-examination of Mr. Kenney, including to show Ms. Gutierrez-Reed's experience that allegations of her being unsafe were not something Mr. Kenney ever heard, that props and armor needed more support, that if the camera crew or others did not feel safe, they should call the hotline. Most critically, he said he received 325 rounds from Thel Reed, which is important because the ammo can be found at his shop, PDQ. The ammo found at his shop, PDQ, was found empty during the search warrant. Mr. Kenney also represented in the Friday, July 12th, 2024 hearing that he brought back 50 to 100 rounds with him to New Mexico and no explanation as to where they went. The state also made repeated points at trial about guns being left unattended. Yet in this previously undisclosed interview, Kenney said that the sheriff confused real and prop guns. Kenny also made conflicting statements on sabotage. This was favorable Giglio information that the state suppressed and that was material. The failure to produce this statement is a clear violation of Rule 5-501, see State v. Allison, reversing defendant's first-degree murder and other convictions and remanding for new trial for the state's failure under 5-501 to disclose defendant's arrest record prior to trial, error not cured. Suppression of the Haag report. The accident involving the firearm that led to the indictment of Ms. Gutierrez-Reed occurred on October 21st, 2021. The state first charged Ms. Gutierrez-Reed with involuntary manslaughter on January 31st, 2023, and trial commenced on February 28th, 2024. Ms. Gutierrez-Reed's principal defense theory was that no one had committed a crime and this was a tragic accident, and if there was any negligence, it was on the part of the producers as found by OSHA. This defense would have been imminently bolstered by a legally unforeseeable intervening cause, such as a firearm malfunction that caused Ms. Hutchins' death. This is perhaps the most important evidence in the case of an unforeseeable intervening cause. Indeed, post-trial, one of the jurors called undersigned counsel and said that the jury was split and that they ultimately thought the tragedy was foreseeable and there was no intervening cause that broke the chain of causation. In short, the Haag report is critical new evidence. On March 6, 2024, the jury returned a verdict finding Ms. Gutierrez-Reed guilty of involuntary manslaughter. The district court entered a judgment on April 18, 2024, when it sentenced Ms. Gutierrez-Reed to a maximum statutory penalty of 18 months imprisonment. But what neither the court nor the jury nor Ms. Gutierrez-Reed knew was that months before Ms. Gutierrez-Reed's trial, the state's two firearm experts, Lucien C. Haag and Michael G. Haag, issued not just one report that the state disclosed, but two subsequent reports. Specifically, the results of the Haag's, I think it's Haag's, not Haag's, the Haag's initial examination of the firearm, performed on July 3rd, 2023, were published in a report dated August 2nd, 2023. The results of the Haag's second examination, performed on August 24th, 2023, were published in two separate reports dated August 26th, 2023 and August 31st, 2023, respectively. The third Haag report found that the firearm contained unexplained tool marks on the working surface and sides of the evidence trigger/sear, and that, one, it was unlikely that these tool marks were the result of damage incurred during the FBI's impact testing, and two, that the tool marks do not appear to be original manufacturing marks or use and abuse tool marks based on their irregular orientation. Put another way, the state's experts concluded that there were unexplained alterations to the firearm's trigger seal, or I think it means sear, a critical conclusion given that Mr. Gutierrez-Reed's co-defendant, Alexander Baldwin, has claimed that he never pulled the trigger of the gun prior to its firing the bullet that killed Helena Hutchins. The state, however, did not produce the third Haag report prior to the commencement of Ms. Gutierrez-Reed's trial. Instead, the state produced them only to Mr. Baldwin, and only weeks after a jury had convicted and the court had sentenced Ms. Gutierrez-Reed. It was only on May 31st, 2024, by which time Ms. Gutierrez-Reed was already at the Western New Mexico Women's Prison in Grants for intake and classification, that Special Prosecutor Morrissey admitted to Mr. Baldwin's counsel that the state failed to disclose the 831 supplemental report for almost 9 months, and that such failure was mine. Please see Exhibit B to Hannah Gutierrez-Reed's motion for immediate release from detention under Rule 5-402, filed on June 27th, email dated May 23rd, from K. Morrissey to Baldwin's counsel. The timeline of the state's discovery disclosures in Mr. Baldwin's case is important to understand for purposes of this motion. On January 24th, Mr. Baldwin made his initial discovery demand. Between April 22nd and April 29th, Mr. Baldwin repeatedly raised concerns to the prosecution about missing expert materials and other missing discovery. Then, on April 29th, Mr. Baldwin apparently learned of the second Haag report when Lucien Haag referred to it during his pretrial interview. It was then more than a month later, on May 21st, that Mr. Baldwin defense learned of the existence of the third Haag report during the pretrial interview of Michael Haag. See Exhibit C on the previous motion. Meanwhile, the state was actively prosecuting Ms. Gutierrez-Reed. Her trial began on February 29th, and the jury delivered a verdict on March 6th, and the court imposed sentencing on April 18th. And during Ms. Gutierrez-Reed's trial, her attorney examined Lucien Haag about the precise exculpatory issues raised in the third Haag report. Mr. Bowles said from the transcript, "Okay, sir, and in your inspection of that weapon, that Baldwin revolver, did you see any modification that would have changed the firing characteristics of that weapon?" No, not at all. Okay, sir. So other than FBI testing, breaking those components, you didn't see any other evidence of modification or damage? I did not. Ooh. At the same time that Lucien Haag gave you this sworn testimony, the state possessed a report stating the exact opposite, specifically that the firearm contained unexplained tool marks on the working surface and sides of the trigger sear that unlikely are the result of damage incurred during the FBI's impact testing. Do not appear to be original manufacturing marks or use and abuse tool marks based on their irregular orientation. Although Lucien Haag's trial testimony directly contradicted his conclusions in the third Haag report, the state continued to withhold the third Haag report and its contents. With the third Haag report, Ms. Gutierrez-Reed would have had a sufficient evidentiary basis from which to argue that unexplained alterations to the firearm caused it to fire without anyone pulling the trigger, an unforeseeable intervening cause that rendered her conduct not legally responsible for Ms. Hutchins' tragic death. This was the critical factor in the jury's decision under the instructions as given. Nor was she able to impeach Mr. Haag's testimony with his prior inconsistent statements. And a few weeks after that testimony, the jury convicted Ms. Gutierrez-Reed of involuntary manslaughter. Suppression of additional material. This week, the Gutierrez-Reed defense has also become aware of another possible 900 or so pages of material related to the state's witness Brian Carpenter and Haag that was not disclosed to undersigned counsel. This material was disclosed to counsel for Mr. Baldwin shortly before his trial. It appears that this material consisted of email communications between the state and those witnesses that were not disclosed by Ms. Morrissey. Counsel are still reviewing these at the time of filing this motion and may supplement with exhibits in a reply. It is too important for Ms. Gutierrez-Reed to have her motion filed immediately, given the July 12th hearing and findings. Just one example, attached is Exhibit E. There are numerous emails, approximately 36 pages, involving Brian Carpenter and state prosecutors. In one dated January 18th of 2023, between state prosecutors and Brian Carpenter, related to the drafting of Mr. Baldwin's probable cause statement. In that email, Mr. Carpenter says in part, quote, "Team, first off, excellent job, Robert. Very compelling document and well written. I have redlined anything I found notable." Unquote. In another, towards the end, he appears to email additional thoughts regarding Ms. Gutierrez-Reed's probable cause statement. As this court may recall, Brian Carpenter was the state's expert witness in the Gutierrez-Reed trial as well. This email is one that counsel has located in cursory search demonstrating the expert's bias towards the prosecution and the fact that he is involved in helping draft a probable cause statement supporting charges. In yet another, he states that Sarah Zachary knew nothing or next to nothing about firearms. He goes on to state that her hiring was for low-budget reasons, and the only thing to mitigate that was to hire an experienced armorer, but that didn't happen again, more than likely for low-budget reasons. Again, blaming production. In another email dated November 17th, Carpenter writes to prosecutors that he has talked to one of the top 3 prop house owners in the U.S. and a very well-known prop master, and both of them, without hesitation, felt major amount of responsibility fell on the prop master. He goes on to believe Hannah is very accurate in saying that her statement that production, were jumping her butt for not working hard on props and that they wanted more done in the props area to save money. He states that Gabriel Pickle was the one from production who stonewalled all the training and armor day requests. He references people believing Gabriel Pickle and members of production being responsible. He notes further blame on production in bringing the props master and armorer in late, not giving them a props truck, and having locations working out of the same truck as being completely wrong and the fault of production. These were all themes that Ms. Gutierrez-Reed espoused at trial, and she never had access to these statements to cross the government's expert Carpenter. In another email on February 6th, Carpenter states that he is reviewing something that appears to reflect a total of 86 live rounds, which is a big thing as they were scattered throughout and found at PDQ. This is Seth Kenny's business, and the number of live rounds found at his business was a source of major contention at trial. Again, all these are statements required to be disclosed under 5-501. The repeated discovery failures are certain beneath what Mr. Gutierrez-Reed deserved. Certainly beneath that. And for her, the impact has been devastating. She now sits in state prison, serving an 18-month sentence based on what we know was a proceeding that was rendered unfair and unconstitutional by the state's conduct. This court should not countenance the state's deplorable behavior. Lenova, thank you for gifting 10 memberships right in the middle of this. Thank you very much. Super, super generous. And thank you for your stock tips and everything as well. Appreciate that. She sends super chats via stock. It's amazing. Law and argument. The state violates a defendant's due process rights when it suppresses evidence favorable to an accused upon request, where the evidence is material either to guilt or to punishment, irrespective of the good faith or bad faith of the prosecution. That's the Brady v. Maryland. Also, Giglio, we've got clarifying that the rule stated in Brady applies to impeachment evidence. Evidence qualifies as material when there is any reasonable likelihood that it could have affected the judgment of the jury. To prevail on her Brady claim, the defendant need not show that she is more likely than not would have been acquitted had the new evidence been admitted. She must only show that the new evidence is sufficient to undermine confidence in the verdict. So this is a higher threshold that she has to meet. She has to, because the decision's already come down, she has to show that this stuff that was withheld would have made a difference in her case to some degree. Undermine the confidence at a minimum level is what they're arguing here. Not that it would have, the jury would have completely gone the other way. It's just that it introduces some doubt. The state of New Mexico, however, imposes heightened obligations under Rule 5-501, noting, the rule creates certain disclosure obligations beyond those required by the Due Process Clause. In particular, the state must disclose any statement made by any witness whom the prosecutor intends to call at the trial that is within the knowledge of the prosecutor. When a defendant has been found guilty, the court, on the motion of the defendant or on its own motion, may grant a new trial if required in the interest of justice. A motion for a new trial based on newly discovered evidence is appropriate where that evidence will probably change the result if a new trial is granted and was discovered after the trial. And it could not have been discovered before the trial by the exercise of due diligence. It is material, is not merely cumulative, and is not merely impeaching or contradictory. The court should order Ms. Gutierrez-Reed to have a new trial or for a dismissal. This is what they want here. This is the big ask. Ms. Gutierrez-Reed is entitled to a new trial or dismissal. Prosecutors bear significant responsibility in the administration of the law, as it's shown in matter of Chavez. It is as much their duty to refrain from improper methods calculated to produce a wrongful conviction as it is to use every legitimate means to bring about a just one. As the Supreme Court said in Berger, a prosecutor may prosecute with earnestness and vigor. Indeed, he should do so, but while he may strike hard blows, he is not at the liberty to strike foul ones. It is as much his duty to refrain from improper methods calculated to produce a wrongful conviction as it is to use every legitimate means to bring about a just one. The conduct of the state in this case is exactly the evil the court had in mind in Berger and again in Brady and Giglio. Under Brady, the state is required to disclose favorable evidence and the defense upon request. See State versus Teresia. Critically, the U.S. Supreme Court has held that the state violates a defendant's due process rights when it suppresses evidence favorable to an accused upon request. Where the evidence is material, either to guilt or to punishment, irrespective of the good faith or bad faith of the prosecution. Moreover, the prosecution for Brady purposes encompasses not only the individual prosecutor handling the case, but extends to the prosecutor's entire office, as well as law enforcement personnel and other arms of the state involved in the investigative aspects of the case. There can be no legitimate dispute that the state violated Ms. Gutierrez-Reed's due process rights under Brady, given that it was now stipulated that it failed to disclose evidence that is both favorable to Ms. Gutierrez-Reed and material to her guilt. As to the first factor, the third Haag report is favorable to Ms. Gutierrez-Reed. It corroborates a defense theory that exculpates Ms. Gutierrez-Reed and would have changed jurors' weighing of the evidence in essential ways. Whatever conduct the state alleged against Ms. Gutierrez-Reed, that conduct was not legally responsible for Ms. Hutchins' tragic death because no one could have foreseen the unexplained alterations to the trigger seal would lead to a freak malfunction causing the gun to fire. If the jury had credited this theory, which the state's own experts' report would have corroborated, the jury necessarily would have acquitted Ms. Gutierrez-Reed. The defense act was a significant cause of death, if it was an act which, in a natural and continuous chain of events, uninterrupted by an outside event, resulted in the death and without which the death would not have occurred. So here he's saying Haag Gutierrez-Reed was only found guilty, and the jury member who called him said this. was only found guilty because she did play a role in it, right? She put that live round in the gun. But it would only be the significant cause of the death if there was a continuous chain of events uninterrupted by an outside event that ended in the death. And the outside event he's saying that occurred in here was the breaking or the malfunctioning of the gun, which is more probable now that we have testimony in that third Haag report of some damaging tool marks that were on the part that broke. So basically the gun was tampered with is what he's trying to say, which would introduce that outside force that led to the shooting. Ms. Gutierrez-Reed was not able to pursue that theory because the state buried evidence in its possession that was necessary for her to make that case to the jury. Nor did Ms. Gutierrez-Reed fail to ask the right question. She asked specifically and repeatedly that the state produce all evidence subject to Brady and Giglio, as well as Rule 501. And then even at trial, even without knowing that Lucien Haag had opined in writing in the third Haag report that there were modifications or damage to the firearm other than what resulted from the FBI testing, Ms. Gutierrez-Reed asked that specific question. Mr. Bowles said, "Okay, sir, and in your inspection of that weapon, that Baldwin revolver, did you see any modification that would have changed the firing characteristics of that weapon?" Mr. Haag responded, "No, not at all." Mr. Bowles asked, "Okay, sir, so other than the FBI testing, breaking those components, you didn't see any other evidence of modification or damage?" Mr. Haag says, "I did not." The fact that Ms. Gutierrez-Reed asked the question and Lucien Haag perjured himself in response should dispel any suggestion that the truth, memorialized in the third Haag report, would have been exculpatory as to Ms. Gutierrez-Reed. Lucien Haag's perjury likewise supports the second factor, that the third Haag report was material to the Gutierrez-Reed case. Evidence qualifies as material when there is any reasonable likelihood that it could have affected the judgment of the jury. To prevail on her Brady claim, Ms. Gutierrez-Reed need not show that she more likely than not would have been acquitted had the new evidence been admitted. She must only show that the new evidence is sufficient to undermine confidence in the verdict. Clarifying that under this standard, the defendant can prevail if the undisclosed information may not have affected the jury's verdict. The facts of this case far surpass that low threshold. The state's entire theory of guilt was that Ms. Gutierrez-Reed's criminal negligence in mishandling the gun caused the death of Helena Hutchins, and that her death was foreseeable consequence of Ms. Gutierrez-Reed's negligence. Ms. Gutierrez-Reed's trial strategy was built on the assumption that there was no evidence suggesting the gun may have been modified or damaged at the time the incident occurred. So here's what he's saying. Our trial strategy was to take into account that there was no evidence that the gun was tampered with, because we had no evidence about that. Had we had that evidence, it would have changed our trial strategy. That's what he's getting at. Had the state disclosed the third Haag report, Ms. Gutierrez-Reed could have used its content to sow reasonable doubt as to causation generally and foreseeability. Ms. Gutierrez-Reed never got the opportunity. The fact that Lucien Haag perjured himself about this very subject when he testified at Ms. Gutierrez-Reed's trial, and that the state continued to dissemble about the third Haag report for months when Mr. Baldwin continued to press, only underscores how important the state views this evidence. There was no conceivable reason to lie and deceive about something that doesn't matter. So he's saying the fact that it was hidden supports the argument that it was something there was something there. Whatever the state's intentions, there is no dispute that it failed to disclose the third Haag report until after Ms. Gutierrez-Reed's conviction and sentencing. Let's look at the email where she says the failure was mine. That was from Morrissey. And that is all that matters. Whether this suppression was inadvertent or intentional does not affect Brady analysis. A violation occurs when the suppressed evidence is material either to guilt or punishment, irrespective of the good faith or bad faith of the prosecution. The state's failure to disclose the third Haag report to Ms. Gutierrez-Reed until months after her trial constitutes a violation of her due process rights under Brady that warrants a new trial. While the violation of Ms. Gutierrez-Reed's rights under the U.S. Constitution is sufficient to vacate her conviction and order a new trial, her rights under the New Mexico Constitution are even more expansive. Under New Mexico law, Ms. Gutierrez-Reed is entitled to a new trial because the state violated its duty to disclose evidence that was material and thereby prejudice Ms. Gutierrez-Reed. First, the state had a duty to disclose the third Haag report under New Mexico law. This sounds repetitive a little bit, but some of these points he is arguing in the light of the rule that applies. And sometimes there are multiple rules that apply to this segment. So the motion to disclose, he's arguing under Brady. He's arguing it under Giglio. He's now arguing that same motion to disclose under New Mexico law. So it's a lot of repetition, but he's hitting it from every angle to sort of bolster his argument. 501 requires disclosure of any documents which are within the possession, custody, or control of the state and which are material to the preparation of the defense. Any statement made by a witness that is within the knowledge of the prosecutor, and any material evidence favorable to the defendant. It creates, and there's also a continuing duty to disclose, noting that 501 creates disclosure obligations beyond those required by due process clause. Here, the state was obligated to disclose the third Haag report under Rule 501 thrice over, because it qualifies as a document material to the preparation of the defense, a statement by a witness that is within the knowledge of the prosecutor, and as material evidence favorable to the defendant. So 3 different ways that document should have been turned over, and it wasn't. Second, the improperly withheld third Haag report was material. The materiality standard in New Mexico law is the same as Brady. Whether evidence is material depends on if there's a reasonable probability that, had the evidence been disclosed to the defense, the result of the proceeding would have been different. A reasonable probability is a probability sufficient to undermine confidence in the outcome. That's the hardest part of his argument. He has to convince the judge that this little bit that was left out could have changed everything. Okay, applying the standard in the failure to disclose context. New Mexico courts, including the Supreme Court, repeatedly have held that the information would have certainly have impact a defense counsel's tactical trial decisions is material to defense. Allison, which was cited previously, for the reasons explained above, the state's failure to disclose the third Haag report undoubtedly affected Ms. Gutierrez-Reed's trial strategy and was therefore material. It did affect it because her trial strategy was that the gun was not damaged. And now the third Haag report shows that the gun was damaged. They would have changed their strategy. So I think he's proved that part. Third, the state's failure to disclose the third Haag report to Ms. Gutierrez-Reed until months after the conclusion of her trial was prejudicial. In State v. Allison, on the way to finding the prosecutor's failure to disclose evidence prejudiced the defendant, the New Mexico court stated that had counsel been aware of the undisclosed evidence, he may have altered his strategy. So here, too. Had Ms. Gutierrez-Reed's counsel been aware of the third Haag report, he undoubtedly would have modified his trial strategy to attempt to introduce a reasonable doubt into the minds of the jurors about the gun's functionality at the time of the incident. At a minimum, Ms. Gutierrez-Reed would have been able to use the contents of the report to impeach Mr. Haag's contradictory trial testimony. The state deprived Ms. Gutierrez-Reed of the opportunity to do so and severely prejudiced her in the process. Ms. Gutierrez-Reed is entitled to a new trial under both the United States Constitution and New Mexico law. Part 3. In the alternative, if they don't grant the new trial, the court should grant Ms. Gutierrez-Reed release pending appeal. In the alternative to an outright dismissal or at least a new trial, the court should grant Ms. Gutierrez-Reed's already filed motion for immediate release pending appeal. A defendant convicted of a nonviolent offense is entitled to release on bail pending appeal if the court finds, 1, by clear and convincing evidence that the person is not likely to flee or pose a danger to the safety or any other person of the community if released, and 2, that the appeal is not for the purpose of delay and raises a substantial question of law or fact likely to result in a reversal or an order for a new trial. Involuntary manslaughter is not enumerated as a violent crime for the purposes of the statute. Moreover, such release is automatic and mandatory upon finding that the above prerequisites are satisfied. For the reasons discussed above, see supra, the first prong of subsection 3111(1)(c) is satisfied. For purposes of the second prong, all that is required is that Ms. Gutierrez-Reed appeal raises a question of more substance than would be necessary to a finding that it was not frivolous, and which, if were resolved in favor on appeal, would entitle her to a new trial. For the reasons discussed above, the facts of this case and Ms. Gutierrez-Reed's present motion amply satisfy that prong as well. For the foregoing reasons, Ms. Gutierrez-Reed respectfully requests this court order a new trial or dismissal of the case for the egregious prosecutorial misconduct. The court should also order Ms. Gutierrez's release. And here's the part he just threw in here on the end. Look at this. Finally, the court should order, under its inherent power, that Ms. Morrissey be removed as special prosecutor from the misconduct that has been found and violations committed in Ms. Gutierrez-Reed's case. By the way, kick out Ms. Morrissey right on the end. I tacked this on. Now we have a few pages of attachments. There's a certificate of service, meaning it's submitted it. It's all good. We have the email from Brian Carpenter, who is the state's expert witness. He's like, okay, this is definitely a little extensive, but I wanted to be thorough when it comes to her. This goes to, I don't know who these people are. I think there's somebody on the state side, investigators or people helping. I approach the questioning in a slightly confrontational manner, so the questions are formulated as such and set to a particular rhythm. I listed out the questions based on my knowledge and what should occur and relied additionally on information provided. The questions are randomly set with intention and sometimes repeated in different format. I hope this gives you what you need and maybe some extra. Of course, you guys will know what to throw away, maybe a lot, and what you need to keep. And by no means is the layout and content anything but a suggestion. If it's wrong in tone or subject, just let me know. At least you should be able to a la carte it. I don't know why this was printed on like a 8-point dot matrix printer, but it looks terrible. I look forward to going over this verbally. Signed B. How did you get the job on the filming of the movie Rust? These are questions they want to ask Hannah. Who directly hired you from the production company? What positions were you hired for? Did you read and break down the script before accepting the position of armorer? Were you aware that this was a gun-heavy movie? Did you know Sarah Zachary, prop master, before being hired? Were you aware Sarah Zachary did not have much, if any, gun experience as a prop master? Did you bring any ammunition with you to the set at any time before principal photography or during principal photography? Did Sarah Zachary bring any ammunition with her in her kit before principal photography? When did the prosecution provide the truck for props to work out of? Who had access to the safe on the makeshift props truck? Was Rust a union show? Did you have a deal memo or contract? So Sarah knew Kenny previously. Kenny placed Sarah on his ATF license in order to handle weapons and rent equipment to make money. Sarah admittedly has never even fired a weapon. Production, according to the statements, did not care to properly address safety matters. This leaves you as the armorer to oversee the entirety of safety set on all the firearm-related matters, while you were also working in props as an assistant. Did you see where I'm going here? Tell me why the situation was allowed to develop initially and then further compound itself until the fatal incident. The following questions and observations are specifically from her interview. Page 8 of the transcript says that her and Sarah helped get the guns out on set the day of the incident. That would mean Sarah touched the guns that day. She also says Sarah helped her with the guns during filming. She was all over the place during her interview with a description of the differentiation between blanks and dummies. She specifically states on page 15 of her transcript that Sarah pulled the gun out of the safe and handed it to her after lunch, where it had been locked during her break. On page 19 of her transcript, she says that Halls was sitting in for the shot until Baldwin arrived. That's usually when a double sits in front of the camera so the operators can line up the shot and grab focus. It's a time saver. Discrepancy on page 21 where she says she's loaded 5 dummies, but one wouldn't go in, and then she cleaned it and then loaded in an additional one, making a total 6. And then the detective asks how many rounds, and she says 5 again. She corrected herself once again on page 21, so the question would be how many rounds did she load into the gun? Again, on page 24, she says Sarah handed the gun directly prior to the incident. On page 28, and previously in her statement, she refers to the fact that the dummy possibly had a live primer. This is not what occurred here. From a ballistic standpoint, this was a completely live round. Otherwise, it would not have generated enough velocity. This is also confirmed by the FBI lab report. When specifically asked about protocol by the detective, she questions the word protocol, then explains the duties of an armorer. I feel quite certain she doesn't understand any separation protocol or has anything remotely in place that would be in a system to mitigate any issues. The fact that Alec Baldwin was inside of the church, and according to Reed, she was specifically told to get out due to some COVID regulation, is a direct, unquestionable breach of safety protocol and a direct action violating safety knowingly. Gauging from the interview with Sarah Zachary, she knew nothing or next to nothing about firearms. In my opinion, there's no version of a prop master with that little knowledge of firearms working in the movie with this many moving parts and guns. So whoever hired her certainly did so probably for cost or tax incentive, or both, rather than her experience level and ability to safely perform her job. The only mitigation to this bad decision would have been a very experienced armorer, which also was more than likely hired for the same reasons. This is all email from Mr. Carpenter, the state's expert. He came up with these questions. Would be interesting to see that the ATF has to say about Seth Kenney's licensing of random prop masters that have no experience with firearms and not directly working for him. Sarah would be considered on his books. What are you describing in your initial interview at the Sheriff's Department, rings on a round? You say several times in your interview that you describe seeing the rings on page 32 after the incident occurred. Not sure what he's talking about there. You say on pages 32 and 33 of your interview that you received some dummies that were wonky. What exactly were you referencing with that statement? You also stated that Sarah immediately called Seth after the incident and that she was aware that there were wonky rounds. You also said that Sarah had told you that she knew where Seth Kenney got these rounds. Explain. You stated on page 34, you get what you get and you're told not to or pitch a fit. Who made that statement to you? Sarah says that Kenney was the head armorer on Walking Dead for 10 years. It's well known in the industry, AMC. The Walking Dead has many safety violations. Were you aware of this? On page 41, you made the remark, I hate myself for that. What are you referring to? The fact that Baldwin was part of the incident or the fact that someone else was shot? Do you as an armorer have your cart or did you all share the props cart? So just to confirm, on page 20 of Sarah's interview transcript, she says that you brought rounds when you came to work on the set of Rust. What were they? Here's another email from from Sydney Halford from Brian Carpenter, or it's to Sydney Halford from Brian Carpenter and to a lot of other people. One more point that might avoid any delays or stalling on those contracts and company info. In order to receive their tax incentive monies, the State Film Office needs to review and approve the project. In MS, you receive a tax certificate after approvals with earmarked funds. New Mexico's process, I'm sure, is very similar as most states are. Having said that, they will have on file a great deal of pertinent information regarding contracts, funding, etc. It's worth a call and may save some time. If you need me to call and inquire on their requirements, I will, as I speak the lingo, or I can provide additional info if needed. Just let me know if you do. Thanks. I'm going to send you the stills. We do have some great information. Earlier he said, Andy, first off, I wanted to say how much I appreciate the hospitality and meeting everyone. It's always good to work with professionals who actually care. As to the visit and evidence review, it was crucial that I saw firsthand the items, most importantly, the deconstructed live rounds and the projectile. This 100% confirmed in my mind what the FBI report contained. Since Monday, I've been able to access a few of the documents remotely while here and wanted to further clarify a few points, as I assume Robert and Harry will probably be digging into this quickly. Also, I was able to cover everything with you via phone. Thanks. So there's no need for a Zoom call. Here are the first blush points. I was able to look at the actual call sheets, specifically for that day. When looking at a call sheet, it's important to know, regardless of what you hear spoken out loud, there's 50% information and 50% ego. You have below-the-line and above-the-line cast crew involved with the filming of a movie, and their placement is specific. This is especially important when it comes to the cast and the above-the-line personnel. Of all the producers, executive producers, and co-producers listed on the Rust call sheet, Baldwin's name was above them all, placed only under director. That is important and noteworthy. Secondly, when searching for deal memo contracts, Baldwin, as an actor, regardless if the show was unionized or not, will still have Screen Actors Guild contract. That's one piece of documentation to obtain. There will also be some type of contract written regarding his work as a producer. If you've already confirmed what LLC the film was actually being made under in the state of New Mexico in order to receive the state's tax incentive monies, then that will more than likely be what the contract name is also written under. As with most investigations, follow the money, executive producers or pre-sale, will lead you to all the other contracts and responsibilities set forth on the show. While piecing together the events of the day, everything lines up so far. What's missing is any footage of what appears to be impromptu rehearsal. Generally, rehearsals are always filmed by camera or cell phone and still photographer who was there for review and setup. The fact no one on set had any is curious. Just a thought. Lastly, I spoke with a prop house owner, one of the top 3 in the U.S., and a very well-known prop master. Without divulging any information or direction, I broached the subject of responsibility on a movie set to get their additional opinions. Both of them, and keep in mind they are very pro-Hollywood in their thoughts, felt without hesitation a major amount of responsibility was on the prop master. This is because we all know how the system is supposed to work on a movie. It may seem differently looking at it from the outside, but from inside it's just the way it is. I also understand from a legal standpoint there will be many hurdles that all of you have to cross. Having said that, I want to give you good information of the way the process works, real world. Hope this makes some sense. If you need anything, just give me a shout, and I will in the meantime continue to digest all the case information. Best, Brian. Let's see, we've got more emails from Brian. He wrote a lot. Hey, I'm not sure what they redacted right here. Maybe his address, but they didn't redact his phone number for some reason. Let's see. This is Sydney Halfords again. First pass. Of most concern was the need to coalesce the armorer, actor, producer responsibilities, as there's a definite overlap that I feel will help us greatly. Here's the note from the red line in case it does not show on your device. Here's where I feel we need to coalesce the armor relationship. If the armor acts professionally and in good faith, but the actors and producers do not, then it's the duty of the armorer to either step down or engage production officially or bring the attention of the unions. At the point all parties reach a crossroad where they decide, is my job and my money more important than people's safety? A good example of this is Baldwin as a producer, even an actor, I've seen this, not demanding production be halted once the most important department for filming, the camera crew, quit the day before. That decision drastically increased an already chaotic and unsafe environment, causing additional stress and confusion with the cast and crew. This obviously was done to save time and money on the production shoot days, a clear and evident lack of management and caring for the safety of others. Reed also chose the path of job/money, and it is documented repeatedly in her statements that she was overwhelmed and not capable of completing the job safely. Just FYI, one of the most asked questions from everyone I'm getting is where the rounds came from. I have a direction on this, and I'd like to share at the appropriate time with everyone. I have notes. Smiley face. More emails. This is just a quick Cliff Notes highlights reel of the 214-page interview with Reed, an attorney. I've voice dictated. Sorry about the grammar. She only worked one other official armorer job, the old way, and apparently was fired or told to leave. She was elusive during the interview concerning this. Following up. She stated that she's been doing PA work, production assistant, since PA is basically a runner or do anything assistant from getting coffee to handing out call sheets. She admitted to the detective she has no official training. So Seth has Reed on his ATF books. She has no idea what that means from a legal standpoint, as she states in her interview. Seth spoke to production and assured them that she was qualified to do the job. The fact that she was key prop assistant and armorer is 100% a conflict of interest. What she says on page 16 is very accurate, that they were jumping her for not working hard on props and told her to focus more there because they didn't understand the gun side of things or safety or didn't care. They wanted more work to be done in the props department so they could save money. Also, as usual in low budget, they brought in props only a week before, so they had no prep time. That put them behind right out of the gate. Gabrielle Pickle was one from the production who stonewalled all the training and armor day requests. So apparently there was some static between her and Sarah because Reed wanted to be more of the boss and run two different departments. So on page 28-29, it becomes quickly obvious that the rounds were just scattered and intermingled haphazardly one with another with no attempt to separate them. She says that she went through a bag mixed together with ammunition and picked out dummies from them. The weapons handling and transport of firearms from licensee to responsible party is unquestionably outside of protocol. Also, Sarah, according to Reed, picked up additional rounds from Seth and borrowed dummies from other people. She obviously had no firearm experience, yet was handling the safety of cast and crew. So the prop truck, that was makeshift in the first place, was also being shared by the locations department for the first week, which means there was no safety protocol or separation protocol. That lies directly on Sarah as the prop master. She also says that Nicole had the code to the safe as well. She also says the truck was never locked, ever, on page 39 of her interview. She admits that some prop masters lock their own truck up. The fact that they brought the prop master in a week before with no prep and armor in just a couple days with no pre-op and didn't give them a props truck, then had locations working out of the same truck is completely wrong. It's all in production, which is the producer's responsibility, which is Alec Baldwin's responsibility. It was also Sarah's responsibility to complain about all this, correct it, and say this is unsafe working conditions with all the guns being present along with Reed. She says on page 41 and 42 that it's super common to leave dummies around unlocked and just out in the open. That is not correct. They should be stored in a safe, inaccessible manner to a random crew. On page 42 of her interview, she states that Sarah helped her handle guns all the time, and all of the rounds, and all of the dummies. She talks about some of the actors doing a safety check on page 48 by opening up the cylinder and spinning it. That's nothing of a safety check. That's just seeing if the guns are loaded. Absolutely senseless when it comes to checking for safety. Reed says on page 61 that even Craft Services, which is called Crafty on a movie, was barely even allowed to make soup for anyone or actual food because they were being so cheap. She says on page 64 that during a safety meeting Dave Halls had on the set, she spoke and clearly told everyone in the crew, don't point these guns at anyone. She says on page 65 that Alec Baldwin stayed on his phone most of the time she was doing training with him on the set of Rust. On page 67, she's being asked by the detective what safety rules she gives actors. It's clear she has never officially had any training for safety as there's no structure or recall. Again, Gabrielle's name comes up on page 73 as the person that made sure actors had only a brief amount of training, and only after Joel insisted. Looks like they didn't train with the horses either for shooting off them on page 74. Again, wildly unsafe. Page 81 and 82, she's talking about the misfires that occurred with Sarah, which is because of the lack of experience and training. And again, with the one actor, with the Henry Lover action, it's a rifle. Also because of lack of safety and training and Reed's lack of set experience. Seth on page 86 and 87 backed up Sarah after she texted him about the dispute between Reed and Zachary. Seth will always back her up because she's the one responsible for hiring him or renting equipment. Page 88, the stunt director tells Reed, don't worry about the stunt guys. They know what they're doing. Some of them don't even know how to operate a gun at all, but the coordinators will always say they do. This is where her youth and inexperience comes into play. Another email. Subject, Baldwin Redline. Team, first off, excellent job, Robert. Very compelling document and well written. I have redlined anything I found notable. The number 1 and 2 would probably be making sure that it reads he was pointing the weapon at Helena, which he factually was, and that he has duties for safety as an actor as well as a producer, effectively doubling his responsibility in 2 different worlds, which overlap in the next one. Lastly, there are a few technical items included. All of this is in the detail in the red line. Let me know your thoughts and if there are any follow-up questions concerning. Now I have an email from Carrie Morrissey to Jason Bowles. Jason, I've decided not to have them tested or picked up. These are clearly dissimilar. She has no subject matter. It's just regarding. I guess he didn't put one in there either. This is clearly dissimilar to the live rounds found on the set due to the primer and projectile characteristics. If you want to have them tested, feel free. I can't see how it's relevant, given that they are clearly dissimilar, but keep me posted if you want to have them tested. If you can't get that done within the next couple of weeks, then you may need to continue the trial if you intend to use them. That was a response to what Jason had written. Said, Carrie, these are pictures from the Troy, the same rounds from that batch that Thel gave to Seth. You had mentioned having police pick these up and have tested. Do you still intend to do that? If not, we need to have them tested. Specifically, having the powder tested, which is important to continue answering the question raised by the recent call we had with you and Jason. Let's see. Melinda Zorma from his law firm said, good morning, please see attached. And there must have been an attachment somewhere. Oh, there are images. Okay, these are the images of the bullets, I think. And that's the end. That takes us to the end. We had 34 pages there. It's a bit of a long read this morning. Where'd it go? So the takeaway here is that Hannah Gutierrez wants the same treatment that Alec Baldwin got and get a new case, a new trial, or a dismissal, or Miss Morrissey fired, or all three. I don't know. We'll see. You can't have a dismissal on a new trial. But he doesn't ask for a dismissal with prejudice. He just wants a new trial, which is interesting. Lenova, thank you very much for your gifted 10 memberships during that. Aaron, Olivia, welcome to the gallery. Thank you very much. Thoughts on this? This is proof that Bowles was aware of them before the trial. He was. And I think that's going to be an obstacle. But there seems to be other violations as well, not just these bullets. These bullets were part of them, but it does seem to be enough. I think there's enough here that the judge should look at this. You're welcome, Melanie. Maybe Bowles can get help from Alex's lawyers. That dude is out of his depth. He got help from them because of all the documents filed in the case. He's just taking stuff out of Alec Baldwin's docket and posting it into his. That's what he's doing. He doesn't need to have them work with him. Depending on the law, he may only be able to ask for a new trial and not a dismissal because the jury already came to a verdict. I think you're right there, Jedi Jess. The state of the case, I think, is in play here. Hannah needs Alex's attorney. That's big money that she doesn't have. I think we read the state's answer to the KR case. No, we read Karen Reed's answer to the state's answer. Dog lover. We skipped the state's answer. Judge still may be mad enough to let her out pending appeal. I think that's what he's trying to get in on. He's like, I filed this emergency motion, right? This says it's an expedited motion for new trial. We want to get in while the judge is still mad. And this is fresh on her memory. Bond, James Bond. So I guess I shouldn't be surprised the defense attorney was apparently as ready to be a crooked prosecutor as Morrison proved to be. It'd be interesting to see if Carrie or the prosecutor would be the prosecutor for a Hannah trial. For a new one, I don't think she would be. I think her time's up. I think the lying under oath allegations are serious enough that might get her in some big trouble. The judge can basically strike this all down, grant an appeal, and release her pending trial. So that can all happen. That's a possibility. Judge did not like Hannah, and it was not the same as the judge's interactions with Mr. Baldwin. There didn't seem to be any animosity between the two at all. But the judge and Hannah, they did not click. Those two were like oil and water. SF in Texas, I disagree. I don't believe she lied under oath. So we have a statement from Miss Johnson, who was her assistant, who quit during the middle of the day, walked up and said, I need to approach. I quit. I have to resign my position. According to Miss Morrissey, she says she quit because Miss Johnson had disagreements about having this hearing done in public. And Miss Johnson, in an interview, stated, that's a lie. I quit because of the late disclosure, and I felt that it was the right thing to do to dismiss the charges. So that was a statement she made under oath. We've also got people who have signed, other people who left her office, who quit, that she testified that, left for one reason, have testified that was not the reason. So I'd say there's some pretty strong evidence that she did lie under oath. Hannah didn't help herself with the jail calls, calling the court and the judge herself corrupt. Yeah, that part, that was pretty bad, listening to those. I also don't think the judge didn't like Bowles. Yes, they're saying that Carrie lied under oath at the very beginning. Specifically, Baldwin's trial exposes extreme misconduct. Special Prosecutor Morrissey lies to this court under oath. And they break it down there. What about a new judge sitting for Monday's hearing? Bev may be called as a witness. Very interesting. Yes, there is a new judge. Let's see. Let me see if I can get the name. I think it was on Twitter. But there's a new judge who will be hearing the Karen Reed case. That's what we're talking about. That hearing on Monday, on the 22nd, is where the state decides if they're going to prosecute again or if I guess they're also going to decide what to do on charges 1 and 3 to see if there's anything that needs to be done in that regard. There is another judge. Yeah. I'm trying to find where it's at. Judge Katie Rayburn is the new sitting judge for the status hearings for the Karen Reed trial. Katie Rayburn is the new judge. It doesn't mean that if there's a new trial that Judge Beverly would not be over that one, but for this hearing, there's a new judge. I don't believe there's any motions to recuse the judge in Karen Reed's trial that I can remember. Why the new judge? Most likely because the facts at issue that are going to be brought up might require the judge to testify as to what happened. And you can't be a witness and the judge in your own case. Yeah, Rayburn's the new judge. Perhaps he can ask for a new trial and then dismiss on day 3. What are we going to watch on Monday? Jury selection on the case. Jury selection most likely will not be shown in the trial that we started, the Black Swan trial. I don't think that's going to happen.
Call from.
Thal, my friend, good morning. Happy Wednesday to you.
Good morning.
You just waking up?
Good morning. Yes. Takes about 3 hours before I'm fully operational, but I did a homework for the channel. So head pats for me.
Good job.
And I watched What's Her Nugget on the whole Karen Reed thing, the judge, and it being them bringing the jury back in to, talk to him and all that stuff.
Yeah.
What's her name? The one lady with the purple hair, glasses.
Emily D. Baker.
There you go. I can't remember her friggin' name. Anyway, sorry. I still think it's Emily. My brain spots out. I'm 46. My brain does this now.
She's
or I'm
only
like
the biggest channel in LawTube.
I'm like, what's her nugget?
She's like 750,000 subscribers or something. She's massive.
Yeah, and when I talk about her, you think I was talking about some no-namer because I'm like, yeah, what's her nugget with the purple hair? Anyway.
YouTube comes to her and asks for help. That's how big she is.
This is very true. This is very true. Yeah, no, the thing is, what she said was really interesting was that since the jury didn't write it down, and she's not blaming the jury, you know what I mean? But she was like, so this is why probably the reason I'm calling in is because you said the judge thinks she's going to have to testify, so this might help explain it a little bit more. Mm-hmm. She said that the thing is that when a jury's in conversations with each other, it's like you can't mess with that ever. Period. They won't ever mess with it. So having said that, they're not gonna bring them in to talk about what they did in the jury room. The reason they brought on people in the Murdoch thing was that was stuff that was happening outside the jury room. You know what I mean? So. Not the same animal.
Remember the case we watched? I'm not sure if you were here. The cold case trial, like 13 years. The guy's finally charged with killing his wife.
Oh yeah.
Remember how that one ended? The jury came back hung, and the judge turned to him and he says, "All right, let's see where your disagreement was. Were you able to reach an agreement on this, on this, on this?" And he dismissed. That's basically what they're saying should have happened in Karen Reed's trial. Is that when they said, "Hey, we're still hung," the judge should have said, "Let's find out the specifics. Were you able to get part of this done or not?" David Swift, that was the trial. Thank you, Zimmy. If you want to go back and watch that, that's what they're saying should have happened.
Well, and the thing is, when you go back and watch it, I think the defense, because the defense, I think, has a point, because Emily didn't really bring this up. She does what Emily does sometimes, which is she'll tell you a bunch of stuff, and you're supposed to put the dots together. Bless her heart, sometimes she's, ADHD, but anyway.
So many of us are.
Yes. But the thing is that where I think the defense has a case to bring it up is on procedural, so that's why they'd have the judge testify. Because procedurally, the judge might have to be like, okay, so what did you find on this charge or this? They might have to break it down for clarity for the court.
Mm-hmm.
And since she didn't break it down, because she just went immediately to mistrial, didn't ask nobody nothing, that is very true. She almost seemed like she was just ready to get out of there and be done with it, which is fine. You know, I get it. It's a long trial. But at the same time, she did just go, oh, okay, you're stuck. Okay, fine. And I was like,
it was abrupt. Okay. We all felt like we sort of had whiplash there at the end. It was like, whoa, you know, it just.
Yeah.
Sorry, I didn't realize I was making you stare at a document all this whole time. It'll be interesting to see what happens. I think the defense is fighting an uphill battle, getting this changed, obviously. But the constitutional rights argument, where they cited some case law that basically says, look, if the jury agreed, they agreed. And whether or not it was on the form, you know, there's a double jeopardy issue that applies. That's going to be their strongest.
Well, see, and here's the thing. This is what I would do is if I was the defense and I can get this judge off the case and get a new judge on it, you know what I would do? It's slimy, but I would pull it all day. Is if the prosecution, because the prosecution needs to do the right thing and just charge for, I think it's the second charge, and stick with that and drop the other two, because they should be pursuing justice, not their own, you know, little funky toe smear. But the thing is, if I was the defense, I'd call the judge as a witness and be like, oh, okay, so last trial, what was the verdict?
I don't know. Usually something like that, when they submit the witness list, the judge might look at that and ask questions. The new judge might look at that and ask questions, and they can, I mean, I've seen judges say, no, I'm not going to let you call a person. So,
well, it'd be extremely prejudicial, but here's the thing is that procedurally, this stuff's already been tried once, and they've already failed, and that might come in. Because the thing is that it's a procedural failure. It's not it shows one more instance of the state failing its duty. You know, and that's what their case is going to be built on again, is the state failed their duty, or the county, or whoever. You know what I mean? So there we go. It fits in that theme of defense. So they might, maybe.
I don't know. I think the judge being called will happen in a motion.
Oh yeah, definitely. No, definitely.
Motion
They're not just going to
not in the trial, but it's
and how? Well, oh, sorry. Go ahead. Sorry.
Oh, you're good. I'm just trying to do two things at once.
Oh, okay. First off, stop doing that.
There's only one of me. I don't have.
This is true.
I wish I had like producers on the back end that would line things up for me. No, I've got to run it all myself. So
you can't, because they're expensive.
I know. They want to get paid, and they want food breaks and bathroom breaks, things like that. I'm like, this is unreasonable. Like we can't.
It's a nightmare. Here's the bright note: you do have kids. So I'm just saying.
Yeah, but catching them performing slave labor on YouTube is probably not the best thing the channel can do.
It's not slave labor. It's incentivized on-the-job training is what it is. Because see, they get to eat then. So.
Yeah, then abuse comes up. So yeah, we've got all sorts of.
It's not abuse. It's forceful emotional investment.
Do you have kids though? Do you have kids?
I have grandbabies. What are you talking about?
All right.
But yeah, but real quick, that defense lawyer yesterday, last thing I want to bring up, and then I'll run away.
Okay.
The defense lawyer yesterday, man, what was with that?
I can't remember.
He wanted to read us like.
Oh, the 74-year-old guy. He's old school, right? He had no laptop. He has a pad of paper, and that's cool. I love guys that can work off a legal pad. That's great. But he's so old school that he's reading like case law from before he was born, and it's just like, man, you've probably been playing these same, you know, you've been playing with the same hand for many years in this game of cards that we're all watching out here in court. And the judge is like, get with the times, get with the, you know, no, we're not going to just listen to you read Supreme Court rulings from 1800s.
Yeah, it was. Well, it's weird because the thing is that we've had a lot of defense lawyers that will either try to BS their way to something, which they're long-winded about, or they're just very short, boom, to the point. This guy was, you're right. He's totally different generation, I think, of make and model of a lawyer, because that was odd. But anyway, I'll let you get back to work and stop bugging you. Yeah, but this is going to be interesting stuff. So
I'm
we got 3 trials. We got 3 trials that are all messed up. This is interesting. This is getting very interesting.
Yeah, it's going to be good. Monday's going to be exciting. We've got a couple other things coming up. I think next month we have the decision on the Brian Koberger case as far as the change of venue, which so we can all book our Airbnbs or hotels appropriately in Boise when we find out. We've got Corey Richens have his 3-day hearing that I'll be at next month in Park City, home of the 2002 Olympics. That's going to be fun. Sarah Boone's coming up, although no letter yet as of this morning. I didn't see any. I'll check one more time. But yeah, there's going to be plenty to talk about for sure. So I'm sure we're going to be hearing from you.
Rock on. Excellent stuff, man. All right. I'll talk to you later, brother.
We'll see you, man. Bye.
Yep. Bye.
All right. Here's my plan. Let me tell you what we're at today. I have a venue training I have to go to. They had one of the venues that I do audio video support for locally just had a massive upgrade, like $120,000 of new equipment, and I have to be there both to learn how it was wired together and teach people how to use it. So we're gonna mix and match that together. But I have to be there today. That's over lunch. We have a couple things going on. We have a new trial that we want to be picking up, but we're going to be a little bit of catch up on. So we're going to watch on high speed once we start, but I'm not going to start it yet. So that's going to start probably maybe this afternoon. Depends on the time. I'll look at the schedule. Maybe this afternoon. But that's going to be the witchcraft trial. So, Jules, thank you very much. It's going to be a lot of fun trip across the country. I just found out from Mrs. R.A. that when we drive across the country, we're going to be, at one point, we're going to go to the world's largest pitchfork. I didn't know that was a thing, but there's like a world's largest pitchfork somewhere, and we're going to go get a selfie there. So that's cool. If the other trial did start, we're going to catch up very quickly. I wish that the upgrade was my equipment, but it's actually the venue's equipment. I just get to use it. Can you upgrade my entertainment system too? All I can do is provide the best entertainment available. I don't. I can give you recommendations though. All right. Yes, the case. Ashley, a man in Iowa killed his mom because he thought she was practicing witchcraft towards him. Yeah, it's going to be interesting, but I think we're going to do it. World's largest ball of string. We're following I think it's I-80. I think, you know how the cross horizontal roads, they're all even numbers, 10, 20, 30, 40, 50, 60, 70. I think we're on 80, so it's going up through Iowa and down through Nebraska over there. Let's see. Take a look at this. Josh, I'll have to take a look at that trial. Thanks for the tip. C. Gilmore, 1, 2, 3. Hello, welcome. I am the entertainment system. There you go. I probably do need an upgrade then. So yes, that's I-80. Red Pen says, yeah, I live right on I-80. There you go. Red Pen, I will wave. Just tell me when. I'll honk and wave and disturb your sleep or something as I go by. Every state has the world's largest something, except for Rhode Island, and they choose like the world's smallest. I come straight to my house in California. Not going to go that far. We're going to stop a state or two east of you. We're going to Utah and Idaho, in that area. We've got the court case in Utah. My son's getting married in Idaho. So we'll be out there for about a month. I say vacation, but I'm working the entire time. So every day I'll be here on the live stream, just in a different venue. I won't be in this studio. I'll be in a different one. I'm taking most of my equipment with me, and and the kids will be out at museums and fun places and water parks and everything else, and I'm going to be right here with y'all. And I think the best I get to do is it's like a hot tub. I could get in a hot tub at night. That's my vacation. Fun fact: my town is home to the world's littlest skyscraper. It is. Thomas, tomorrow, you and me. Last I heard, we're still going to do a podcast. That's going to be tomorrow night at 8 p.m. We don't need a live stream. Don't need to live stream the hot tub. Thank you, Greeners. I had come to that same conclusion. I ruled it out early on in my planning.
If they didn't, I would lose my mind.
I would lose my mind. Dig for gems. Oh, Donna. Just outside of, I say just outside of Delta, like 50 miles outside of Delta, there's a place called Topaz Mountain. It is I think it's federal property. It's BLM, I think, but it is.
I saw a chicken fight.
It is a rock hounding area open to the public, and you can go and just dig topaz. And for those who have never been out there, topaz is a beautiful amber-colored gemstone, gem quality stone that is everywhere. As a matter of fact, if you go at night and you put like a headlamp on and you just walk along, the ground glitters. It just sparkles from all the gems that are sitting there. It will blow your mind, but you don't want the ones that are on the ground because the stone, the topaz, when it comes out and is exposed to the UV rays of sunlight, it goes from that amber color.
Don't miss the forest for the trees.
To crystal clear. It turns crystal clear.
If they didn't, I would lose my mind.
Jules 04th for the road trip. Thank you very much. I appreciate that. I've been out there a couple times doing the rock hounding. Even one time when they dynamited, there's a like the whole place is a horseshoe shape, and it's like acres and acres and acres. It's huge. It's massive of place to dig and find these gems. But in the very middle is sort of like the richest area for the gems, and it's a private claim, and they'll dynamite it occasionally. So you can pay them, and that's where you get massive specimens. But I think they have some specimens in the Smithsonian from that. It's the only place you can find it. It's a beautiful rock. Dog Lover says, Jen Del Rio says, were you ever a radio guy?
I was kicked back, taking it easy.
I was a TV guy behind the camera. I took radio and TV production in college as part of my degree, because I got my degree in electronic media. But that's about it. So I've never actually worked at a radio station. I've worked at a TV station, though. Sorry if I'm being too nosy, but how does income work for you when you don't have that many views because of you doing lives and not videos? Dog Lover, I'll tell you, I'm very blessed to be in a financial situation where I have very little expenses. We buy old cars, we buy used. We're frugal. We're very frugal people. Mostly, I say we. My wife makes great financial decisions, and because of that, our bills are pretty low, and it allows us to survive on very little. Our first house we bought, it was actually what do they call it? They call it a HUD home.
People do not get to have it their way.
It was like a first time home buyer's plan, and we bought it I think for $89,000, which was all that we could afford. And when we bought it, and we lived there for a long time, and the value just went nuts while we were there. And we were able to sell our house and then buy our home now and pay for it cash. Now we moved to North Carolina where the cost of living is much lower. We bought a house that was much cheaper than the one we sold was worth, and so we were able to pay off our home. So I have no debt, like zero. I have no credit card. I have no home debt. I have no car debt. There's zero debt in my life, which is unbelievably freeing. And although I don't have many really cool things as well, other than what I have for my job here for the studio, it makes me pretty happy. So because of that, the little we earn from YouTube, we can get by. Anyway, so yeah, my wife, she's a business management major, and she's amazing. Buy crypto. Apparently, Bitcoin's doing well right now. It's going back up. Libby says, I figured out what I want my YouTube channel to be about. Now I've got to store up some motivation to actually do it. No. You're doing it wrong, Libby. You're doing it wrong. And I say that in the nicest way. Start before you're ready. The best advice I can give anyone is please, please, please start before you're ready. Just go live. And don't worry. Start before it's like, oh, it needs to be perfect and right. I need all these parts and pieces. If you have a cell phone, you probably have everything you need to start. Now, once you get going, I can give you recommendations on what to improve and how, but you don't need to make a huge expenditure of anything. The first thing you want to upgrade is not a camera. It's not new computers. It's not, fancy, graphics and audio. It's just audio. Get a good mic. That's your first upgrade. And then once you've got good audio, then make a little upgrade to your video, and just make small improvements, and it'll help. But if you wait until you're ready to go live, and you're like, okay, now I've got it all put together, it's never going to happen. It's never going to start, because no one ever feels confident that they're there. And I'm not there now. I mean, there are things about my setup that I really wish I could change, but luckily for me, I was in a state of desperation, and I just went live immediately. Best advice: you'll never think you're ready. Live streaming is 90% tech and finding out. Yes, and this is the rest. Everything that happens on YouTube, as far as making videos and going live and everything else, everything is figure-outable. Meaning that most of it you can learn from watching other people on YouTube, either people you'd like to emulate and be like, or learn from watching videos on YouTube. It'll teach you how to do this, and YouTube itself has videos to teach you how to do this. They benefit when you build a channel, right? That gives them one more venue for them to sell advertising. And they'll do that as soon as you start. Once you reach a certain threshold, they'll start splitting the advertising cost with you. But anyway, that's... Let's see, that's it. You'll be so close, you should come visit Thurston County, Washington. I'd buy you an SRA lunch. You got to see this place in real life. I'm not sure. I've said enough about Thurston County, Washington. I'm not sure the cops. I'm worried that I'd cross over the gore point and find myself in jail. Marcia Braga says, oh, we got Jules on the phone. Hang on.
Call from
Jules.
Jules, how are you doing? Notorious.
Good morning. Yeah, I'm doing the best I can. Just recovered from a bout of COVID. So yeah, it was really bad. But thank God I'm negative now, and I'm on the road to recovery. My taste and smell started coming back yesterday. Yay!
Wow. Yes, that's really good.
Yeah.
Are you planning on attending court?
I am. I will be attending the Benefield hearing. I'm not going on the 22nd, though. That's jury selection, and I have no desire to do that. And I'm probably going to skip opening statements and start going once they actually start taking testimony. And because it's in Manatee County up in Bradenton, it's an hour's drive. It's not really that bad. So, yes, I will be there. And then, as you know, on August 1st, Dr. Joe and I will be at the sanctions hearing on the Kowalski case.
Yeah, fun stuff. I haven't run the numbers to see what the number's up to, but it's close to 9 million or maybe over 9 million now on the interest.
I know. I love it. But, yeah, the family's doing really well. They're trying to live life as normal as they possibly can. Kyle's doing great. Maya's doing great. Jack is getting back into the swing of things. So, hopefully after the first, I just hope that Judge Carroll makes a ruling on that day, and that we're just not going to.
It's time to see some sanctions. We've talked about it for so long. It's almost like we're forgetting the offense. It's been so long, but
exactly.
I'm excited,
so
Jules.
That's what we're hoping for.
I'm glad to hear you.
Benefield?
Yes, we're covering Benefield. So we'd love to hear from you as a court watcher, as we've had you done before, if you're able to do that. So.
I will, but I'm going to be like uber careful this time around because I don't want to be.
Whatever.
I don't want to be named
We're in a
any
different
more
county now.
post-trial
I know we're in the
motions.
same circuit, 12th Circuit, Florida, but we're in Manatee instead of Saratoga, so it's like it's all
Correct.
It's all different.
Correct.
Jules,
Yeah,
good to hear your voice. I'm
gonna
glad
be
you're feeling better.
Thank you. I couldn't call in for weeks because all you would hear me, like after 3 words, I would start hacking like a mad person. So, but anyway, I want to say hi to you. Enjoy your road trip.
I hope, well, I'm planning on it, but I've never done a road trip like this, so I might say never again. We're taking the train back. I don't know. We'll see what happens. We'll sell the car, take the train back.
Wait a minute. Oh, you're going to put your car on the Amtrak train?
Or just sell it and buy one. If the road trip is that bad, we'll find a way to not road trip back. But flying's not an option for us. So.
Okay.
But
all right.
We'll figure it out.
Well,
we'll keep you guys updated.
Yeah, I'm sure you will. That'll be fun. I wish you were coming to Florida, though. But in any case, I know you can't fit everything in your schedule. I understand.
I'll be back soon. Florida has a special place in my heart, at least the beaches. And I've got metal detectors that need to touch Florida sand. So we'll figure it out.
Okay, take
all right,
care.
thanks, Jules. We'll see you.
Guys in the chat. All right, bye-bye.
I left this on the screen. Marcia, I've got suggestions for you. If you've got 60,000 subscribers, first of all, you're a bigger channel than I am right now. That's a lot of people. It shows there's an audience out there. The rules are frustrating. I'm wondering if maybe you might have had an experience with like a copyright strike or something like that. Give me if you're interested in starting again, I might be able to give you some suggestions, and it might be a little bit of a change from what you were doing before. But with 60,000 subscribers, you've got quite a community built up, and there's stuff you can do. Debbie says, I still only have 190 subs. 190, that's better than none. It's a good place to start. I would just work on consistently putting something out that matches, that sort of has to match your niche, your audience. They found you and subscribed to you for a reason, and if you keep giving them that, they'll keep coming back, and YouTube will recommend it to more people who will also do the same. But if you jump around a lot, people get confused, and they're like, I don't remember subscribing to a channel that was about this, and they'll unsubscribe. Let's see. When I went to college, it cost $200 or so for a semester. Back in my day, I had a bicycle. Let's see. Let's see. Eric, hey, my friend, we'll be in your neck of the woods soon. Hope to be able to connect. Somebody says, let's see, Nosy Rosie. I'd love to see the interest count.
Call from
Bree.
Bree, hello. How are you doing?
Good morning. Since we're randomly talking to, as my dogs bark, of course, since we were talking about how to make new YouTube channels, I'm going to create a channel. I'm going to go outside so she can't bark. I'm going to teach people how to watch Recovery Addict and get the best out of their time. You know, like how to set up the perfect snipping clip. So, like, you know, when Hannah's phone name comes out in the public, or when Morrissey gets asked if she called Baldwin a C word. You know, those perfect moments that only you give us. I'm going to teach people how to clip those great so they can send them to Toys, and then we can make some great YouTube and TikTok videos.
That is awesome.
That's going to be the new YouTube channel of the year.
I tell you, one thing that will make it go completely viral is if you can teach people how to win the internet, like the trick to winning the internet on my channel. Because a lot of people,
can you call me and teach them how to do that?
Yeah, that's going to be the viral video. That's the one that's just going to take off. No, it's funny. I actually love that you guys find enjoyment. I am just me, right? And a lot of times if I were playing poker, I would lose every time because I do not have a poker face. You know, I see a good card, I'm like, ooh, you know, my eyes light up, and you're like, oh, he's got aces. But that's you're the beneficiaries of that as we're watching court.
Well, the
things
best
get
part
exciting.
the best part is that when I say wholesome, not in a bad way, but you would think that court would be wholesome. You would not think these things are being said in a courtroom. And when they, hold on, dogs are just not having a good day today. I apologize, chat. But when you're so wholesome and then they say these things, you're like, wait, that should not be said in a courtroom. So just the look on your face is always so priceless.
It's surprising, and sometimes they're said with great effect.
Oh yeah.
But it's funny. I do like going back and seeing some of the clips that people get, and especially TYO Toys. Phil does a great job. Oh my goodness! Yeah. If you're on Twitter, that's the first account you need to follow. I mean, I know they say like, hey, do you want to follow Elon Musk? No, you want to follow TYO Toys. He's the first one. And then some of the rest of us out there they're on Twitter are good as well. But
and I think due to a special water fairy, and that's all I'm going to say, I think you have a package coming.
Water fairy.
Yep.
All right. I will watch for that. We'll swing by the post office. Sounds good.
Well, I can't send it to the post. It can't go to the post office box. That's all I'm saying.
Oh.
So you may have something coming to you.
Ah, you did some heavy research then. Okay, sounds good. All right.
All right, guys.
Excellent.
I'll talk
Thanks,
to you guys
Bree.
later.
Good talking to you. We'll see you.
Gotta go ground my dogs that bark. Bye.
Bye. Weather Watch says, what did she just call me? A water fairy. You're a water fairy. I never knew, Thomas. I never knew. I'm obviously we're going to change your name for the podcast to the new name. Let's see. Ivy says, just to be aware, my 86-year-old's dad deletes the internet on a daily basis and does not even speak English. Oh, man. Let's see. When R.A. was not paying attention during Letitia, and a certain adult moment came up, R.A.'s face popped right up and his eyes popped down. We've had a few moments that have been surprising. I'm behind now, but good on you, Mrs. R.A., for being frugal. Happiness is found in people, not things. Yeah, I will say we are incredibly blessed, and I feel rich. Does that make sense? Yeah, my house constantly has more repairs than I can afford to make on it, and my cars get repaired as often as they get oil changes. but I feel rich, and I love that. It's a very liberating feeling, and it's been great. I think I wouldn't change anything about it. All right. Let's see. I have to go because I've got to go to this venue, and it's going to be great. I was going to check out Sarah Boone's case one more time. Let me just do that now. And we have no new letters from Sarah Boone. Okay. I feel rich for a couple of reasons. First of all, I'm able to do something that I love for work, and it's able to pay the bills. That for me is huge. I don't know how many people I've talked to that don't enjoy their work, and waking up in the morning is a depressing thing when they think that they have to go to work again. That feels terrible to me. I realize that I am blessed beyond belief that I'm able to do something I absolutely love, wake up excited to do. Like in my spare time, if I wasn't doing this for work, I would do this, which is just, it blows my mind that this can happen. So, and in all this, I've got amazingly supportive wife who is absolutely incredible, and some amazing kids, and it's just I think I've got all that in a bucket of ice cream. It's just good. So I want to thank all of you for that, honestly, because this wouldn't be possible without you. That you guys make that possible, and so thank you, honestly, from my heart, bottom of my heart, from me on my family. I appreciate that. Lynn says, watched Canton Board last night. I giggled when a little someone mentioned going to a town meeting because I have to attend one tonight, not to complain, but to support the store next door. Lynn, we accidentally, not accidentally, I purposefully raised my hand, and I did get called out on that town meeting and spoke on the meeting. Just briefly. Didn't want to take a lot of time, but interesting. They're going to keep doing town meetings via Zoom for the time being. Thank you, Nosy Rosie. Thanks, everybody. Next time you head to Florida, please hit us with R.A. and Randy. Please hit us with R.A. and Brandy Lucy crossover with y'all metal detecting on the beach. Perhaps put a GoPro on Lucy for peak POV footage. I'm not sure I could keep up with Lucy on the beach. That is her home territory, and she rules there. Greeners. graders. I don't think so. All right, that's it. We're gonna break. When we come back, we do have we're planning on picking up a trial that has started already. So we're gonna do a little catch up. We do that by watching at a little bit higher speed. We get caught up, and then we watch the trial live. So we will have a new trial here shortly. Hopefully that'll be over, or we'll take breaks as needed to cover some of the pressing issues in the other court cases we're following, namely the Karen Reed trial. Also, we have very soon we've got the Ashley Benefield trial that's going to be starting next week, sometime maybe mid next week. I haven't heard the date yet. Depends how jury selection goes. Thank you, Keshet, for sharing the message. All right, what time? I don't know exactly when I'll be done, Ricky. I wish I could tell you. I'm hopeful for this afternoon. Nothing like a good cry this morning that makes my heart full for you. Thank you, Megan. I appreciate that. I'm nothing but just happy. I'm just one big smiley face emoji right now. So thank you all. All right, tonight when you go home, please hug the people you love. Smile at someone, make their day just a little bit better, and please stay safe till we go live again. Hopefully this afternoon with a new trial. Fingers crossed. Keep your notifications on and watch for those, and join us because it's going to be fun to pick up a new one and follow Witchcraft Murder. What? Yeah, sounds crazy. All right, have a great afternoon. We'll see you guys in a little bit. Bye-bye.
If they didn't, I would lose my mind.